Hello and welcome to this Croner-i eCPD module on security deposits prepared by Meg Wilson. In certain instances, HMRC can require a person to provide a deposit or bond if they think there's a risk the person won't pay a particular tax or duty on time. This is known as a security. This module will concentrate on the direct taxes that HMRC can require a security for. It will enable you to help your clients avoid being required to provide a security or to advise them should they receive a notice of requirement. It will do this by looking at when HMRC can require a security, how much security can be required, when an appeal against a notice of requirement might succeed, and the provisions included in Finance Bill 2018-19 extending the securities legislation to construction industry scheme deductions and corporation tax. Securities legislation currently applies to the taxes and duties shown on this slide. As mentioned earlier, this module looks only at the implications for direct taxes, so PAYE deductions and Class 1 and 1A national insurance contributions. The legislation for PAYE deductions is in ITEPA 2003 Section 684 and SI 2003 2682 Part 4A. The legislation for Class 1 NICs is in SI 2001 1004 Part 3B and applies to Class 1A NICs by virtue of Reg 83A. The legislation provides that an employer can be required to provide a security for PAYE Class 1 or Class 1A NICs where an HMRC officer considers it necessary for the protection of the revenue. This will usually be where there has been a serious non-compliance and HMRC consider that the collection of PAYE and NICs are seriously at risk. The security deposit system is not aimed at those people experiencing genuine difficulties in paying the tax they owe. Such businesses should contact HMRC to agree a time to pay arrangement. HMRC will normally send a warning letter before issuing a formal notice of requirement to say that they may require security. However, if HMRC believe that by sending a warning letter there may be an increased risk that PAYE or NICs won't be paid, they may send a notice of requirement without warning. Once HMRC have decided to require a security for PAYE or Class 1 or 1A NICs, they have to decide who to require the security from. It could be that they demand it from the employer themselves, but they also have the option of requiring it from a director of the employer, a company secretary of the employer, any other similar officer of the employer, any person purporting to act in such a capacity, or, where the employer is a limited liability partnership, HMRC can require the security from any member of the LLP. Certain employers are exempted from being required to provide securities. These are the Crown, employers with time to pay arrangements, and care and support employers. Liability to give security will be joint and several in cases where it is required from more than one person. In practice, HMRC are happy for the security to be given by any or all of those people, as long as the security is given in full. Once HMRC have decided that a security for PAYE or Class 1 or Class 1A NICs is required, and who to require it from, an HMRC officer must give notice of a requirement for security to each person from whom security is required. The notice must specify the value of security, how the security is to be given, the date by which the security is to be given, and the period for which security is required. The notice must also include or be accompanied by an explanation of the right to ask for a time to pay arrangement and the effect on the timing of making such a request. Where a security is being required by more than one person, the notice must include or be accompanied by the names of each other person from whom security is required. If the notice of requirement does not meet these requirements, a person will not be treated as having been required to provide security. Advisors would therefore be wise to check notices carefully. The date included in the notice of requirement as the date on or before which the security is to be given must be a minimum of 30 days after the day on which the notice is given. However, If before that due date the employer requests a time to pay arrangement, the requirement to give security on or before the specified date does not apply. If HMRC refuses the employer's request for a time to pay arrangement, security is to be given within 30 days after the day on which HMRC notifies the employer of their refusal. How much security HMRC can require is not detailed in the legislation. HMRC calculate the amount of security using a formula based on the amount of PAYE and Class 1 and 1A NICs paid or due to be paid by the employer for a 4-month period, plus any current arrears of PAYE and Class 1 and 1A NICs due. Although HMRC used the amount of PAYE and NIC arrears to calculate the security amount, they will continue to pursue payment of any arrears in the normal way. If an employer gives security and then fails to pay PAYE and NICs due, HMRC may use some or all of the security to pay what they owe and may then require a further security. A person who's given security may apply to HMRC for a reduction in the value of security that HMRC hold if the person's circumstances have changed since security was given because of either hardship or the person has stopped being a person from whom security can be required, or since the day the security was given, there has been a significant reduction in the number of employees of the employer to whom the security relates, or the employer has stopped being an employer. All recipients of notices are given appeal rights against the notice or any of the requirements in it, or against a refusal to reduce a security requirement or to reduce it to the extent requested. The appeal must be directed to the person who issued the relevant notice or letter, stating the grounds, and the usual 30-day time limit applies to any appeal. Ultimately, a tribunal can confirm, reduce or cancel the security imposed, or confirm or vary a decision on a request to reduce the level of security. In 2016, the First-Tier Tribunal decided that while HMRC's decision that the giving of security was necessary for the protection of the revenue was not unreasonable, the amount of security required was excessive. The Tribunal saw logic in HMRC taking the figure for security as the current and previous year's PAYE NIC debt plus 4 months PAYE NICs. However, the Tribunal considered that the appropriate amount of security should also have taken into account that regard had to be had to the fact that the consequences of a failure to provide the security was that the recipient of the notice would have committed a criminal offence, and there was nothing in the legislation which set out what matters were to be considered in setting the amount or value of the security. In particular, although hardship could be a reason for a reduction in security that had already been given, it was difficult to see why it should not be a factor in the initial decision to require security. The Tribunal did not consider that adherence to a policy which dictated the amount of the security to be required without having regard to the ability to pay was consistent with the scheme of the legislation. It did not consider that the taxpayer company was in a position to provide security for the amounts of the arrears, and to require it to do so would simply have had the effect that it would fail to comply and be criminally liable, and that would do nothing to protect the revenue. Instead, the Tribunal decided that security based on a recent 4-month period was a reasonable approach, and it therefore reduced the amount of security required. In a First-Tier Tribunal decision released at the end of 2017, the Tribunal dismissed a taxpayer company's appeal against HMRC's decision to require security for PAYE and NICs. The amount of security required represented the amount of PAYE and NICs due for 4 months. HMRC submitted that they required the security because the company's sole shareholder had been involved in previous businesses that had gone into liquidation with considerable tax liabilities, and the company's business was the same type of trade carried on from the same premises as the failed businesses. The FTT found that HMRC had correctly taken into account relevant information available to it, such as the company's recent good PAYE and NICs compliance record, and concluded that HMRC's decision to require the security was reasonable, as were the requirements regarding the manner in which the security was to be provided. It's a criminal offence to not give the PAYE and NIC security shown on the notice of requirement. If HMRC send a notice of requirement and the recipient does not give the security in full, HMRC may prosecute. If the prosecution is successful, the person may have to pay a fine. The value of the fine would be set by the court and has no limit. The government plan is to extend the security deposit system to include construction industry scheme (CIS) deductions and corporation tax. The extension was consulted on between March and June 2018 and aims to strengthen HMRC's ability to deal effectively with defaulters that pose a serious risk to revenue. Again, the measures are not aimed at those businesses experiencing genuine difficulties in paying the tax they owe. Such businesses should contact HMRC's Business Payment Support Service. Securities may be required if a taxpayer has a poor compliance record, or if, for example, an individual had a previous business which accrued a tax debt, went into liquidation or administration, and the individual then set up a new company. Company directors and officers may be required to provide security for a company. The detailed rules will be introduced through secondary legislation which hasn't yet been published. HMRC intend to make the regulations to come into effect no earlier than 6th of April 2019. The detailed rules enabling HMRC to require a security for CIS deductions are to be introduced by secondary legislation which has not yet been published. They are expected to be very similar to those for PAYE and NICs. As set out in Finance Bill 2018-19, the regulations must provide that a security can only be required when an HMRC officer considers it necessary for the protection of the revenue, and decisions concerning securities, i.e. whether to require one and the amount, terms and duration, are appealable. The key things to remember from this module are: firstly, to warn non-compliant businesses of the risk of being required to pay security for tax payments. Secondly, to make sure you check any notices of requirement your client gets to ensure they adhere to the regulations. Thirdly, to know the case law concerning securities, to know when it might be worth appealing against a notice of requirement. And finally, to be aware that the securities regime is being extended by Finance Bill 2018-19. I trust you found this module on security deposits informative. Please exit this activity and click Launch Quiz to complete the quiz. Once you've completed the quiz, you'll be able to print out your personal certificate. The module homepage also contains a link to the notes that accompany this module and to further resources available to you from Croner-i, including quick overview commentary summarising when HMRC can require a security deposit. Goodbye, and thank you for using Croner-i eCPD.
For further information and to view the full range of Croner-i eCPD modules, visit our website at croner-i.co.uk.